everyone. Welcome to the ALPS session on global copyright issues in AI. I am so happy to be here, and a big thank you to PLS for organizing today. And just because I'm American, in case there are any other Americans in the room, a very, very happy Independence Day. I am delighted to be joined today on this panel by Sarah Fricker and Mark Walford. Mark Walford has over 30 years' experience in academic publishing and currently holds the title of VP Rights and Business Development at Sage. His role at Sage involves combining responsibilities for global rights and licensing, contracts, and copyright with public affairs and acquisitions. For a number of years, he has chaired the UK PA Serial Publishers Executive Committee, presumably, notably particularly during the debates around the development of the UK government Finch report on open access. And he continues to serve on the STM Legal Forum, as well on the PLS board representing the Publishers Association. We also have joining us Sarah Fricker. Sarah is the group head of legal at Institute of Physics, where she has spent over 20 years leading a team providing legal advice to IOP companies around the world on issues including copyright and licensing. Sarah is also a non-executive director at the Association of Learned and Professional Society Publishers, ALPS, which is the sponsor of today's session, where she also serves on the policy committee. She is also a member of STM and likewise serves on the board here of PLS. And finally, me, I am Leslie Landsman. I am Global Permissions Manager at Springer Nature. I am also a director at ALPS, along with Sarah, where I chair the policy committee. And lovely to see you all here in the room today to talk about my favorite subject, copyright. So to begin, where are we? How do we understand copyright in AI? What are we going to talk about here today? We really have three choices in front of us as to how we understand copyright, scope of protection, and what's going to happen in the future. And these are litigation, legislation, and licensing. I know some of us might wish we could pause and somehow turn the clock back and start things all over again, but that's not the situation we are in. We are in the, where we are right here today. So what is AI? AI really marks the advent of an era of what I like to call cheap creativity. Whereas historically, it would take a man, and it usually was for the thousands of years that books was being created, a man, a very, very long time to sit there and make this thing that we would call a book. Very, very soon, absolutely anywhere in the world, no matter what their background, their language ability, their education, would be able to be something that we would see as something like a novelist or an author, and be able to put something on the market that might very much confuse the consumer as to what, who was behind it. This is not necessarily a bad thing. Increased opportunities for diverse voices to find the means to express themselves will be found. New types of creative works using technological tools will flourish. There will be opportunities everywhere to still have new ways to be creative, and this is really what copyright tries to stimulate, is creativity, originality. But if this cheap creativity subsumes human creativity, or if readers have no idea how to access human authorship, we might have a problem ahead of us. So how do human creators not get lost in the middle of all of this? And how do we allow consumers, rights holders, the public, and the developers of AI to all try to coexist in some kind of peaceful relationships? To help us, we have the incredibly flexible, adaptable, and with a great proven track record tool of copyright. Although we still have many unknowns as to the scope of copyright in AI, copyright does provide solutions, and understanding the global questions that copyright asks will really help us all to frame our individual responses and answers. So there are three main avenues, as we've just said, where copyright seeks to achieve its role as a balancing tool between rights holders and the public: litigation, legislation, and licensing. So let's start by looking at litigation. And we're going to start by looking at AI and authorship. I think sometimes when we think of AI and authorship, it might be easy to think there's two distinct buckets. There's the human author or there's the robot author. Well, I think in reality, the future is going to be a lot more muddled and a lot more mixed. Authorship, although currently AI outputs are mostly amateur, abundant, and of little commercial value, this is also most likely to change. As tools become more sophisticated, so will the humans who use them, and more pervasive opportunities for using AI will start flooding the creative industries, and particularly publishing. So what are the courts and what is litigation doing about this now? And we're going to talk about two different situations. One up here, Li v. Liu was in China, and we have a recent decision. Well, this is a question arose as to whether this image that you can see in front of you reflects a copyright protected work. Is it the thing that copyright attaches to? And therefore, if somebody else came along, as happened in this case, and reproduced it on their blog, would that therefore be an infringement? So what did the court say? In its decision, the court bypassed actually many of the technological aspects of what kind of went on here, and it really focused on human involvement. And it said, from the time when the plaintiff conceived the picture involved, in the case to the final selection of the picture they selected, the plaintiff has made a certain amount of intellectual investment, such as devising the perspective of the characters, selecting the prompt words, arranging the order of amount of content being used, using certain types of filtering tools to come at the final image. And all of this reflected, and in the end what the court held, meets the requirements of an intellectual achievement, what the Chinese standard is for what we might here call in UK or Europe originality. So here is a plaintiff who was able to prove, mainly by showing a lot of pieces of paper, all the steps he went to create this image, that he had entered many prompts. He had then gone into several different ways of using different types of photoshopping tools to create this final image. And he had a lot of proof to back this up. This is different than what, and unfortunately there isn't a picture because this was hard to find. There's a more recent case in Prague here in Europe. Here, the court found that the author of an AI-generated work is conceptually the human operator, but legally, AI lacks the status of legal personhood and therefore cannot be the author in the eyes of copyright law. The court did kind of suggest, similar to what we just heard in the Chinese court, that if the plaintiff or the claimant in this case could have shown that they had entered more of that intellectual investment, made more of those creative choices, perhaps it could rise to a level of authorship for copyright purposes. But as it was, all the claimant had was his word. He said, I'm the one who put the prompts in here. This is what came out. This is what happened. And the court found that this was insufficient, but did suggest that there might be some other way that we might prove sufficiency in terms of reflecting those authors' own intellectual choices. So where does that leave us? So AI can be a tool for human creativity, but whether it allows copyright claims depends probably on the extent of human involvement and probably on certain levels of proof as to what level of human involvement that was. It is most likely that all levels of output in creative industries, particularly in publishing, will involve some level of AI in the future, but whether that just be on a certain kind of basic level or obviously more substantive, remains to be seen. However, authorship is obviously not the only question that goes on when we're talking about AI and litigation. We're not going to go into the complexities of all of these cases, but more to give you a bit of a sense of what is going on. And this is actually out of date already because the case in the middle in Tennessee was just transferred to California a couple days ago. So already my information is obsolete. But this is a way when we talk about AI. But we can see here litigation, and this is around training, really around the extent of the fair use defense, which is a particularly American US defense to copyright law, and whether or not it applies to the training of large language models. Here you can see also we're really kind of setting up a jurisdictional, suit to say, probably because we want to at some point get the Supreme Court involved and reflecting the two main creative industries, New York and California. So these cases are progressing, and as we can see already, this map is a little out of date. So while it seems that we are proceeding to understand some things in terms of litigation and copyright and AI, it's very unclear where this is going to go. And it's very unclear when in the future we're going to have concrete answers from any legislature as to the extent of any legislative current rule or future rule. And also it's unclear, particularly with the US defense of fair use, what application that would have for example, in Europe, where the EU AI Act imposes certain obligations on any person who is doing dealings within the EU. So where are we? One thing we do have, again, as we said, is copyright. We have been here before, and copyright solutions have generally helped us keep pace with the times. No matter what the technological development, copyright has usually come along and found some kind of solution or answer that has helped us. So turning to our panel a bit, and for this bit, I'm going to change seats. And opening it up a bit more for discussion. What do we think here? What do we think of what is going on in the world when it comes to litigation and copyright? What do we think publishers are doing when there's not a lot of answers when it comes to understanding levels of authorship, levels of originality, or what is going to happen when it comes to these infringement cases? Sarah?
Yeah, I think, I hope everyone can hear me okay. I think as well from what was said in the previous talk is that licensing, most people will be surprised to hear me mentioning that today, is the way that the industry has found in the past, and I think will find with AI the best way forward, whether that be individual or collective licensing. I think the question over what content will be protected by copyright is an interesting one. But I think at the moment, most publishers that I'm speaking to are saying that what they are concerned about is they don't know what content they currently have in these tools. They don't know what it's being used for, and they want to understand that for their own purposes, but also for the purposes of the authors whose works they publish. So there is this unknown, and I think that's the thing that people are struggling with at the moment.
And I think also in the output, because even if authors want to somehow use AI tools, if those tools themselves could be infringing, then how much can we rely on publishing them and making them available to a wider audience?
Yeah.
Mark?
So I hope you can hear me. I thought it's very interesting to have that slide up there and just to think back to, because the thing that struck me when AI first appeared is what is this like? And strangely, I felt it's like the arrival of photocopying, that suddenly it was possible to produce multiple copies of a work really easily. And I'm kind of aware that the CLA and the PLS exist partly because of the development of the photocopier, and that the answer to that problem was not within completely rewriting copyright law or saying, well, you can't possibly legislate for this. It was that actually licensing provides a way forward. I think to the question about what's in those LLMs, probably almost everything already. It would be my take on that. And the previous speaker over on the other side just said something about, in essence, some of these deals that are being struck are really like a please do not sue us type deal. Mm. So as to the question of, has an author used something, can we get certainty of, in a sense that the inputs that we're dealing with are legitimate, I think that is a real challenge. There will obviously, most authors act honourably, if you like, but if they can't tell, or if they choose not to act honourably, that's much more of a challenge.
Yes, I'm sure I'm not the only one who has been exposed to many of these different services out there that say, we'll let you know whether or not you've been trained. I sometimes question who has not been trained. I mean, what is it? Who's excluded from this? It seems if you've written anything, you're going to be, it seems like an easy business. Yes, you have been. Everyone has. Oh, there's your answer. Yeah. But what does that mean? What does it mean to have your work incorporated in to other people's, particularly as something that I like to talk about from a copyright perspective? We have the author of Calvin and Hobbes, who's definitely been in there and famous for refusing to license his content anywhere. He doesn't, he has refused all licensing, and we can see from the outputs of these, these LLMs that his work has definitely been included.
Yeah, and I think there are some real concerns at the moment, and very legitimate ones, about some of the quality of the output that's coming from these AI tools, and how, and again, it was touched on in the previous talk that to actually just rely without doing any form of human checking on some of the outputs of these AI tools is dangerous at the moment. I mean, that will get developed, but I think that is an important, an important thing to bear in mind when using them, that not to rely on them completely.
Yeah, I definitely think so. Well, moving on just a little bit, although we will continue to bring up some of these threads again, another way that we understand the scope of copyright is, is legislation. So what are global lawmakers doing? And you can see by this slide that they are up to quite a bit. What are the rules that lawmakers are looking at, and what are the things that they are trying to deal with when it comes to AI and policy developments? As I am American and it is Independence Day, I'm going to talk a little bit about the picture in the US, where here again is a little bit of a map. We have a big mix. We have a lot of federal, different types of federal legislation that are in the mix, a lot of executive orders, and we have a lot that's happening in the states. Just a few of these things I want to pick up on. We have the US Executive Order on Safe, Secure, and Trustworthy Development and Use of AI, the White House Blueprint for an AI Bill of Rights, and then we have more than 40 states now which have adopted or are in the process of adopting new regulations. So a lot is going on in the US, and regulatory authorities such as the Federal Communications Commission have reissued declarations saying things like existing laws still do apply. In that sense, they were referring to some 1980s law about communication practices and what it meant for voices and the protection of voice, your own voice, when it comes to AI. So rights holders are acknowledged through a variety of these different legal instruments, but what is the scope of this acknowledgement? What is it actually going to mean to the rights holder? How does it interplay with what's going on in the courts? And how can rights holders and authors properly be safeguarded? Several leading AI companies in the US, such as Adobe, IBM, Google, Meta, OpenAI, etc., have voluntarily committed to help move towards safe, secure, and transparent development of AI technology. These companies committed to internal and external security testing of AI systems before release, sharing information on maintaining AI risks, and investing in safeguards. But who determines what any of those words mean? Those words might mean something very different if you are in an AI company than perhaps if you're somebody who's sitting in that room. And so I think that some of these overtures, particularly when you see in the news things about perhaps what goes on in terms and conditions from AI companies, we always should be quite skeptical and do quite a close read of what exactly is going on. But we do see that there are some real concerns over what does it, not maybe repeating the same mistakes that we have previously made with new technologies, not having some types of rules, some types of structure around. But as we know, what's going on in the US is a little bit up in the air right now, so we are kind of waiting for that federal authority to really take over because copyright really exists within federal law. So perhaps to take a little bit of a look at the UK, Mark.
Yeah, so this is, in a way, this is going to be slightly a game of two halves. So the UK's had a copyright exception for non-commercial text and data mining, and I'm sure you're all aware that if you like, the boundaries between text and data mining and AI are not clearly mapped out, that you can't do AI really without text and data mining, but you probably can do TDM without doing AI. So we had a copyright exception introduced in 2014, really is, from what I remember, with basically no consultation. And then, because of the way these things work, 2019, there was a review of that copyright exception, a non-commercial one, which found no evidence really of any impact, which in a sense is not surprising because no one was doing text and data mining in 2014, so it probably just squashed people from doing it. But the result of that was, and this is touched on next door, this kind of enthusiasm in the government of saying, well, why don't we have just a general copyright exception for text and data mining? So this predates AI slightly. There was a whole flurry of activity. There was an attempt to produce a code of conduct. there was an attempt simply to introduce an exception which was very, very firmly sat on by all the copyright industries working together, and indeed quite a lot of the tech industry saying, even the tech industry saying, was saying, we don't need something this broad and this kind of punitive to content owners. Anyone who was at the PLS meeting, this meeting, I think 2 years ago when all the government ministers were resigning, there was a bit of discussion about that. That's when that was going on, when the government minister was saying, who wants this kind of thing? And so we're sort of back to the drawing board now. Obviously, it's election day today. We don't know what will happen from tomorrow onwards. I'm hoping that Will Crook and colleagues in the kind of policy session later will be able to tell us, basically. Shall I move on to the next slide?
Yeah, please. Yeah, so I'm just going to talk a little bit about the EU AI Act, which again was touched on at the previous session. It's been talked about for a long time, so I imagine most of you will have at least heard about it, but it was formally adopted by the EU Council just over a month ago. And basically, it is seen as an encouraging sign in the whole kind of idea of regulating AI, because the EU's stated ambition is to become a global leader. And again, using the terminology Leslie was using then to do with the US, they were talking about being trustworthy. It's in terms of modelling, for those who work with the EU GDPR, there are some similarities in that what is likely to happen with this act is it will be seen as the gold standard for AI, which other countries will then emulate, which I'd say is what has happened with general data protection regulation essentially around the world. Under EU law, those who work with it will know that it becomes law 20 days after it's published in the official journal. So that's likely to be around early August. And what it basically does is it proposes a risk-based prescriptive approach to AI systems, and it puts them into categories, what they call single-purpose AI systems, which, as the name suggests, are systems that are set up to do one specific thing, and the general-purpose AI systems like ChatGPT. And that there would be transparency, you know, that word again, it's all around transparency, requiring AI companies to stipulate what data they're using and whose data it is. They're what they call high impact AI models. So the whole sort of gist of this is that they are looking, rather than having one size fits all, there will be some general standards for all AI systems and then more detailed prescriptive ones for those that are seen to be higher risk. For those who say, well, we don't need to worry about EU law now because we're not in the EU anymore, no. If these AI companies have systems that are basically functioning in the EU, they will still have to comply with this act. It's not known whether AI companies will have different versions for the EU, whether they'll have if they're going to comply, if they're going to have a system that is gold standard EU across the world, but they will have to comply with the EU AI Act if they're operating in the EU or having EU nationals' data. And it's rolled out in batches, so it doesn't all come out. There's not one day when this act will be in force. It will be rolled out from early summer of next year to summer 2027. So imagine the PLS forum next year will be looking forward to the first batch of regulation coming out. But I just wanted to talk a little bit, again, because we've talked about text and data mining. There is a direct correlation, as Mark just alluded to, between text and data mining and AI, so this is relevant. There are 2 articles in the EU directive which deal with text and data mining. Article 3 is pretty much the same as the UK text and data mining exception because it talks about non-commercial text and data mining. And it basically means that if someone has lawful access to content, they can text and data mine it for non-commercial purposes without needing any other permission, and you can't contract out of it. Article 4 says that people can do text and data mining on content for any purpose, so commercial included, unless the copyright owner specifically opts out. And they can opt out in a human readable way, so by putting something on their article or book saying not to be used for AI without permission, or text and data mining without permission, and it can also be within the metadata of the article or book. As we've said a few times, there are differences of opinion as to whether TDM and AI go hand in hand all the time, or whether you can have one without the other. But there are clear overlaps. It's difficult to see how these AI companies could do what they're doing if they weren't doing some form of text and data mining. And I did want to also mention data protection, because this is something, I know we're talking about copyright today, but data protection is irrelevant here and is sometimes overlooked by courts and governments. There is personal data in the content that these AI companies are using, whether it's author names or contributors. And we know that there are only specific lawful purposes when you can process someone's personal data. And it's undecided, as unfortunately a number of things are in this area, whether the AI companies can say that they are lawfully using this individual's personal data, or whether that might be something that needs to be looked at. And the ICO, the Information Commissioners in the UK office, is looking at how data protection and AI can work together. So just to kind of put up as an end point there, that data protection is relevant as well. So over to you, Lizzie.
So I think that we can kind of summarize what these are some of the core issues that global lawmakers are looking at. And just picking up on a few of the things that we've talked about already, I think it's important to know the value that rights holders associations, trade associations bring when dealing with some of these global issues. For example, we were just talking about data protection. I know because we worked on it together, but ALPS has been very involved in working and responding to the ICO and trying to provide information to the ICO here in the UK on what is happening to authors and how authors feel about having their own personal data potentially being swept up into these AI models. Similarly, we were talking about some of the complexities between text and data mining and AI. I hope many of you saw the session earlier in the day when CLA was talking about the difference in their licensing approach when it comes to collective licensing for text and data mining versus their collective licensing for generative AI. And I would also like to highlight, even though they're not officially here today, but STM has made a publicly available, free to use, on their website, very easy to find, and it's not bespoke to the STM publishers. It really is available to all publishers and whatever your discipline may be. And it really is a toolkit, and it helps you to explain how you can comply with what Sarah was just talking about, how you can comply with both machine readable, opt out of that Article 4, or opt out of text and data mining generally. How do you let people know in the world, I don't want you to do this, these are the rules I want to do this in both a machine readable way and a human readable way. So I really do encourage you to take a look at these different trade associations, keep on top of what they're doing, because they really are on the front edges of providing some very useful solutions to some of the problems that we have just been talking about, particularly things around ideas of transparency and what does that mean. I always get questions like, transparency to who? Is it to all of us, to every single person in the world, transparency? Is it transparency to the rights holders? Where does that transparency lie? Any other thoughts on legislation and...
No, I think what we've touched on throughout is that there are words and kind of terminology that is sort of threaded through all the different legislation, that even if they're treating it potentially differently. I think, as you say, transparency, security, again, authors' rights were touched on at the last session, but they are important. So I think these will form a common thread. But you're right, Lizzie, I think, if you're a member of a trade association, it is good to keep in contact with them about these things, because these are all things that we're all grappling with. I think copyright, personally, I think copyright has a place now and in the future, and it will accommodate and, it will move with these things. But this is all new, and I think, just get as much information as you can from the industry itself.
So far, we've been talking a bit about litigation and legislation, but in reality, it's going to be a really long time before we get answers to what's going on either in litigation and legislation. And as we've already seen, it's most likely that different territories are going to have different approaches, and it's going to be a little bit difficult if you are a global distributor to understand whose rules you should apply to, when and where. And luckily, copyright still has an answer for us in the terms of licensing. So Mark, as our kind of resident on the stage at least,
Okay.
Licensing expert, what are your thoughts on licensing?
Well, I suppose the thought that occurred to me when you were just having that little interaction was my response to the question on legislation is don't wait for it, because licensing is already possible in the sense that within the licensing environment you get at least to negotiate the terms under which content is used, to negotiate some of the issues around attribution and so on. And I think from the point of both from the point of view of as publishers and either owners of content or those who are kind of holding content on behalf of others, we actually have a responsibility to look at licensing solutions. I think, first of all, because otherwise we are not necessarily doing the best by our content producers, but also because one of the ways to, in a sense, guarantee that legislation doesn't go our way is to not come up with licensing solutions, is to not say, well, actually, if you want to use this material, here is a way to do it legally in a way that rewards content owners and content creators and so on. Without that, if you like, the tech companies, the companies that would argue this is all fair use, it's all fair dealing, it's too complicated to legislate for, etc., etc., will just say, look, well, we'd love to license it, but these people won't let us. So I think kind of my message in a way is, as with photocopying, it is possible to license this stuff, and it is possible, therefore, to build in protections which help deal with authors' concerns and choices. It's possible to license for different purposes. AI is not one thing. It's possible to do it in ways which are both which are reassuring and remunerative. And the alternative, I think, is chaos, basically.
I think one of the beauties of live licensing, you just alluded to, Mark, is its flexibility.
Yeah.
I think as this is, there's no reason to wait. We can have a license now, which might need to be amended, updated as this technology develops. But at least you've kind of put a line in the sand, and you have something to work for. And as you say, these companies can then not honestly say that our only option is to use the content without permission. There is another way.
Yeah.
Yes, I definitely think that licensing is a human answer to a lot of the things that we've been talking about that might exist outside of our control. Licensing is what really gives us control. And while a lot of what happens in terms of litigation or legislation can be affected, particularly by action across the creative industries, publishers working together through trade associations, etc., it is licensing and individual partnerships that will ultimately kind of paint the landscape of how AI truly functions and we truly do achieve those objectives. So in order to leave time for questions, we're going to end here. But I do think while Mark wanted to go back to the photocopy, and anyone who knows me knows that I would go back to 550 AD in the Battle of Culdreven. But what this does remind me of is about 5 years ago, and the photograph. Similar to today, when people first saw the output of a photo of a camera, they thought this is cheap creativity. This is not the works of an artist who is an oil painter or someone like that up until that time. This is something that is mechanical. This isn't the type of thing that copyright attaches to. This is a case, about Oscar Wilde, where it was indeed held that copyright applies. And nowadays, it would seem crazy to us that photographs can't receive copyright protection. Over that last 125 years, everything from licensing schemes to digital libraries to particular trade associations for photographers to particular legislation providing for particular rules around originality and copyright for photos in places like the EU have developed. And 125 years is really not that long of a time, but now it's very much within us and standard. So I do think that, as we say here, copyright will find a way. Don't panic. With that, a big thank you to my panel.